Morning, everyone. This is the time set for the oral argument in cause number DA 22-0645 in the matter of the mental health of TW. And I understand, Ms. Peterson, you're going to reserve 10 minutes for your rebuttal. Is that correct? Okay. And Justice Gustafson, you can hear and see us okay? Yes. Okay. Ready to begin, counsel?
Good morning, and may it please the court. My name is Kristen Peterson, and I am pleased to represent Appellant and Respondent TW. TW comes today asking this court to preserve the integrity of the jury system and Montana law's respect for those the state seeks to institutionalize for forced mental health treatment as a last resort.
Ms. Peterson, can you pull the mic a little closer to your...
Is that better? The state cannot compel a respondent who knowingly wishes to waive their appearance at trial to be spotlighted by Zoom against their will for the express reason so the jury may inspect them for mental defects. And a jury's verdict cannot be reduced to a mere dress rehearsal for a second successive petition and second jury trial within days of the first, where the state takes another bite at the apple on the same evidence the prior jury rejected to prove the same theory as to the same person's need for commitment for being unable to care for her basic needs. This case presents two issues for this court, either of which is grounds for reversal of TW's involuntary commitment to Montana State Hospital. First, the district court turned Montana law on its head and unlawfully forced TW's remote appearance at trial by Zoom through an unmuted and video-on connection, despite TW's request to waive her appearance. Second, the district court incorrectly ruled that claim or issue preclusion categorically had no impact on either A, the state's ability to proceed on its second successive petition, or B, do so by use of the same exact evidence presented at the previous jury trial that had ended with dismissal on the merits on that jury's finding that TW did not require commitment. We will start today by addressing TW's compelled remote appearance. As we know, this case involves back-to-back commitment petitions and back-to-back jury trials on those petitions within days of each other after the first jury found TW did not require commitment. At TW's second jury trial, she made the same request that was allowed at her prior trial to waive her appearance and watch trial by Zoom from a separate room where the video and audio were off. Although the state did not previously object, this time the state objected and argued TW should either be in the courtroom or audible and visible by Zoom, expressly so the jury would have the opportunity to observe her mental condition. The district court agreed, reversed course, and determined that jury was entitled to inspect TW for mental defects. The court allowed TW to go to a separate room and watch by Zoom, but required her video and audio to remain on to facilitate her personal inspection by the jury. The district court persisted in that order despite TW's objection and her unequivocal request to not use Zoom at all. The district court's ruling forcing TW to remain on Zoom violated Montana's civil commitment scheme and the rights it granted TW to be present and participate in the proceeding and waive that right if she so desired and was capable of doing so under 5321-119 and 5321-140, which she undisputedly was. Montana's involuntary commitment scheme is part of a rather recent development in the law to establish strong procedural safeguards for those facing involuntary commitment. The scheme is to be administered with full respect for the person's dignity and personal integrity, as well as to ensure them due process of law. As part of this scheme, the respondent has the right to be present and participate in a proceeding. 5321-119 expressly provides a capable respondent may waive their right to be present and participate, and this court has consistently interpreted 119.1 to only confer discretion on the court to ensure the waiver is knowing and voluntary. 5321-140 piggybacks 119 on a person's presence by Zoom, making it subject to the waiver provisions of 119 and providing in subsection 5 that a respondent can choose not to appear by Zoom at all.
Ms. Peterson, can I ask you, On section 119, we don't have any case law that has interpreted the facts that we have here.
No.
We haven't seen that fact scenario and the implication of 119.
That is true, Your Honor. I mean, this court has consistently interpreted it in such a way that that the court's only discretion is to ensure that the waiver is knowing and voluntary. And relevant to this in this regard is this court's decision in INRI PAC, a 2013 decision, in which case the respondent's attorney represented that the respondent didn't wish to be present, and the court reversed that because there was not a sufficient record that the waiver was knowing and voluntary, but made sure to state very clearly that obviously there is no reason to require a respondent like PAC to attend the hearing before her attorney can inform the court that she wishes to waive her right to be present. Such a requirement would elevate form over substance and would be a disservice to the respondent who does not wish to attend.
But that statute requires the concurrence of the professional person and the judge. So, I mean, it appears that the judge has discretion whether to agree to that request for waiver for personal presence. So isn't this an abuse of discretion issue with the district judge?
No, Your Honor, I believe you're looking at 119 subsection 2.
I am, yeah.
And we're looking at, this case falls under subsection 1 of 119. This court has always interpreted 119 to provide really 3 ways for a waiver of a person's presence. In 1, the person can personally waive. 2, if in the second part of 1, if they're not capable, they can waive.
Why wouldn't sub 2 apply? That's the specific factual scenario that applies here. Why wouldn't we look at the subsection that's on point with this issue?
Well, because I believe that the factual situation actually does fall within subsection 1. We have a capable respondent who has clearly expressed her desire to not be present, and as this court has consistently interpreted, which is consistent with the respondent's right to dignity and right to her liberty, is to respect those wishes of a respondent. If they
Understood, but
present.
the first line of sub 2, the right of the respondent to be physically present at a hearing may also be waived. That's what we're talking about. Why wouldn't we look at that subsection and see that it requires concurrence of the professional person and the judge?
Well, because I think the plain language says also. So it's not the exclusive means by which to waive the respondent's right to be present. And it does fall under subsection 1. And that's how this court has interpreted 119 since in several decisions in the 2009 case of INRI LK, the 2013 case of INRI PAC, 2018 case of INRI SD.
So the distinction there is you're saying TW made a knowing voluntary waiver under sub 1. Sub 2 is if the respondent's unable to make the waiver, then you look to the attorney and the friend of the respondent to make that request. Is that what you're saying?
Yes, unable.
Is there a friend of respondent even appointed in this case?
There was.
Did he or she make that? I didn't look at that specific issue.
She did, yes, actually.
Okay.
In both proceedings, there was a record made that she agreed with the waiver. So yes, I would say under a respondent who's not capable or for whatever reason we don't know what their desires are.
But the respondent in this case, did the district court make a finding that she was making a knowing waiver, or was the judge relying on the friend and the attorney to make that waiver?
The judge didn't make a finding explicit finding that it was knowing, but that's supported by the record in this case. She was consistently throughout the proceedings and clearly stated in the first proceeding she didn't wish to be present for reasons that made sense. As the record reflected, she was agitated, it was emotional. She particularly was affected by the professional person Valancourt's testimony. And so that is supported by the record in this case.
Did the judge make a finding in the first trial? Do you know? Not that I want to bring in the first trial too much here, but.
Sure. So I don't know that there was an explicit finding, but he did
Allow her to.
agree with the representations. It didn't raise any issues with the waiver.
Okay, thank you.
So correct me if I'm wrong, but I thought that she actually asked to appear
I believe you have the sequence wrong. So if in the second trial, this was all discussed pre-trial. It was prior to voir dire, the request for the prior arrangement was made, which really was never a Zoom appearance per se. She had always, if we go back to the first case, she had said she didn't wish to be present and she didn't want to participate and kind of asked for this Zoom accommodation, really. So we get to the second case, she's asking for the same situation prior to voir dire. That's when the court, I believe, makes its ruling that it will allow Zoom this time, but she does have to, it's essentially going to be a Zoom appearance now, and the video and audio will be on. And then she, I believe, objected at that time to those conditions. And then after voir dire, again objected to the conditions and asked to not be present, to waive her right to participate at all.
So at that point, then she was prepared to just turn off her connection and
Yes.
not be at all.
Yes.
Up to that point, just to follow up on one of Justice McKinnon's questions, the statute doesn't neatly apply to this situation until that point, does it? Because she wanted to be present in some capacity, at least to be able to see and hear what was going on, but not in other capacities. And so the statute doesn't quite address it. Would you agree with that?
I would agree that prior to her her willingness to completely not use Zoom at all and her request to not use Zoom at all, that the statutes were a little unclear of what could happen.
So is that how 140 comes into play?
Yes, yes. To the extent there's any ambiguity, then 145 subsection 5 comes into play. She unequivocally objected and did not wish to be on Zoom, and she was forced to remain on Zoom with her audio and video.
But where's the fundamental right for her to not participate? I mean, the entire proceeding is involuntary. Of course she doesn't want to be there. Probably nobody wants to be there. But that's what I'm trying to get at. Typically what we're dealing with is someone's fundamental right to be present at whatever proceeding is trying them here. Here, you're invoking her fundamental right not to be present and not to participate. Where's that coming from?
Your Honor, it's implicit in 119.1, and as this court has consistently interpreted to provide 3 mechanisms for waiver, one of them being a respondent can choose not to be there if they wish not to be there, and that is consistent with the respondent's right to dignity and the respect that the proceedings accord her.
What's the authority for that?
So we're looking at 5321-101.
Oh, I mean, the tying that to her individual right of dignity.
Well, Your Honor, the statutory purposes of the involuntary commitment scheme in 5321-101 explicitly provide that the rights are to be, the scheme is to be interpreted according full respect for the person's dignity and personal integrity. And it's actually in that provision as well. The ruling essentially forced TW to be State's Exhibit 1, and any relevance to her presence was entirely prejudicial and encouraged the jury to rely on their prejudices. This court recently stated in re JDL that exhibition of erratic, unpredictable, and unconventional behaviors is precisely the reasons the civil commitment statutes provide for a means of waiving a respondent's right to be physically present at a hearing. We don't want jurors to decide in isolation of specific expert testimony whether certain behavior is or is not consistent with a mental disorder. Here, the district court not only allowed this, but basically encouraged it by spotlighting TW herself by her video and on from a separate room. The state has made no argument the district court's ruling was permitted under 119, and the state implicitly concedes error is reversal because it only argues harmless error as to the preclusion issue. And indeed, the error is reversible under this court's 20 years of waiver precedent. If there are no further questions, I will move on to the preclusion issue.
The last thing I want to cover on this 140, the two-way electronic audio-video communication. The statute defines that as allowing all of the participants to be observed and heard by all present. So the concern, going back to Justice Baker's question, the concern I have is she wants to not be present, but she still wants to be available by audio-video visualization in some way. And so that's, she's not really invoking her right not to be present. She's trying to still see and hear the proceedings, but not have anyone see and hear her. And I don't know where we get that under the statutory construction.
So we have to go back to the first proceeding, which she always requested to waive her appearance. And she never, as I said, requested a Zoom appearance per se. What kind of was developed was this, the district court allowed, since Zoom apparently was available, there was a person that could watch with her, allowed her to go in this room and watch by Zoom. So at the second trial, when she makes that same request, there is discretion in the court there to determine if this is practically again possible. But where we clearly get is when the court is saying, I'm only going to let you do this if your audio and video are on, and she says, okay, well then I don't want to do it at all, and the district court forces her to remain on Zoom, then we're clearly under subsection 5 of 140, and it was not allowed.
Let me follow that up. I'm just trying to understand what the statutory basis for the district court's decision was, under what subsection, and this takes us back to, I guess, this difficult interpretational question of 119.1, which doesn't mention waiver of appearance at all. It's a generic paragraph, and maybe we've applied it that way, but it's a general provision discussing the waiver of a person's rights in general. And then subsection 2 says the right of the respondent to be physically present at a hearing may also be waived, as in addition to the rights we're waiving under 1, subsection 2 allows or addresses the respondent's appearance at the hearing, and it seems like under the facts here, the basis for the district court's decision was 2B, that the respondent had voluntarily expressed a desire to waive the respondent's presence at the hearing. Is that the subsection we're under here?
So the district court and the parties didn't necessarily clearly explain what section we're under.
Right.
We're arguing this case falls under subsection 1 because of the also in subsection 2, and as this court has consistently interpreted, to provide 3 mechanisms for a respondent's waiver, including when they wish to waive their right to be present and are capable of doing so.
Counsel, it seems that subsection 2 is there to be invoked by the court when frequently in these types of proceedings you have a respondent who can be disruptive or prevent the proceeding from occurring so that their waiver is required. I
Yes.
think that's what subsection 2 addresses.
Yes, absolutely. So moving on to the preclusion issue, we would like to start by addressing this court's decision in INRI LCB. There are 2 main parts of INRI LCB to address in this case. The first is the court's discussion of civil commitment cases within the final judgment element of claim preclusion. We agree with LCB that a finding at one time on a person's mental health is not intended to be a final and irrevocable decision on that matter, and that a commitment petition can be brought at any time as long as the necessary statutory criteria are met. We disagree with LCB and ask the court to overrule it to the extent LCB held on this reasoning that a petition can never be subject to claim or issue preclusion. That was the proposition the state relied on LCB for in the district court and potentially does so again on appeal, that the preclusion doctrines as a whole never apply to civil commitment cases because the final judgment element is never met as a matter of law. Rather, we ask the court to hold the preclusion doctrines can apply to a civil commitment judgment if the elements are satisfied in a particular case. Civil commitment judgments should be available for preclusive effect just as virtually any other civil judgment is, even more so in this context where there are heightened rights and interests that are not at issue in the typical case, as the court recognized in the 2000 case of INRI JS.
Counsel, so how do we deal with, I mean, these are difficult cases to handle and manage, and we have maybe parts A, B, C, D, which are heard in the first trial, and then we add E, and we need to still address the commitment petition with the additional component. How do you try that second case when all the elements A through E are still relevant to mental health, the mental health of the respondent. In other words, how can you try the case when you've got a new fact E without all the other information building up to it? It's still relevant.
So, Your Honor, we're getting past the motion to dismiss stage, and now we're into the discussion of really what evidence to proceed on in the second petition. And it's important to look at this in the context of this case. So the first jury heard from Captain White, from Kayla Friss, from Amy Johnson, from Valancourt, the respondents, their interactions with the respondent in the weeks leading up to the first trial, and the mental health professional's conclusions at that time that she required commitment for being unable to care for her basic needs, and decided on that evidence she did not require commitment for being unable to care on her basic needs. So when the state brings another petition, they're bringing it on the same theory, which is important in this case, as that this is going to her basic needs. That evidence, consistent with preclusion doctrines, we have to respect the prior jury's verdict. They decided legally and factually that on that evidence she did not require commitment for being unable to care for her basic needs. So we can't consider that evidence in isolation from the jury's verdict, and really as probative to her need for commitment, because the jury disagreed. This is what gives meaning to judgments.
But don't mental health cases involve two bifurcated issues, whether the respondent suffers from a mental disorder that requires commitment, and then if it's found that the respondent does in fact suffer from a mental disorder requiring commitment, then you can have a separate trial at which the disposition is addressed unless the respondent waives and agrees to combine everything. And wouldn't issues A through E, I guess I'll go to whether she suffers from a mental disorder requiring commitment, and then the issue preclusion applies to the disposition. I guess I'm confused. Everything got conflated here.
Yes.
And the statute, clearly mandates that respondents have a right to separate trials, whether they're bench or jury, on those two distinct issues. So maybe help me process that, because LCB, I just wonder what happened on the day after the jury verdict on the first one, where she called 911, and then when the police arrived, she had escaped. How does that play into your issue preclusion argument?
So issue preclusion is really going to the criteria of did she suffer from a mental disorder, but more importantly in this case, if she required commitment. And that is what is subject to the fact finder's decision, and really where issue preclusion comes into play, apart from the appropriate disposition in this case.
So then are you arguing that only fact E should have been brought to the jury's attention, and that it should only have been brought on what disposition was appropriate if she suffered from a mental disorder?
We are arguing that the trial, if the new petition is based on what fact E, that's what started it, then the new trial needs to be primary, especially when we have a jury verdict that just considered this exact issue on basic needs. This jury verdict, considering the same issue of basic needs, has to rest primarily on fact E to respect the prior jury's judgment. Their factual determination, they've listened to all of that evidence, and they decided on the evidence she did not require commitment for being unable to care for her basic needs.
So the second trial was confined only to the issue of disposition?
No, the second trial was confined only to the issue of her inability to care for her basic needs.
So the two issues were not bifurcated like the law allows. She must have waived and then allowed everything to be argued in one trial?
No, Your Honor, there was still a separate dispositional hearing held after this trial. It was just the jury trial was that fact. The jury was asked to determine, did she require commitment for being unable to care for her
Okay,
basic
so then you're arguing that Justice McKinnon has said, typically with mental health it's so complicated that the history of a person is what we hear about at the district court level on whether someone suffers from a mental disorder requiring commitment. We generally hear from the beginning of time when the mental health issues began. So you're saying that in this instance, because there was a jury trial and the jury determined that yes, she did suffer from a mental disorder, but did not require commitment, that A through D, I guess, F at
I'm so sorry.
whatever, I'm so sorry. Everything other than E could not be brought up ever again, even though it's part of her mental health history?
So what we're arguing was we have to look at what happened in this case. And in this case, the state presented substantive evidence of A, B, C, and D to prove that she required commitment for being unable to care for her basic needs, and the district court disagreed with that. So we get to the new petition, we're at the different point in time, and what the state is trying to do is prove she requires commitment later by, again, providing substantive evidence through A, B, C, and D, the same people testifying to the same facts. It could be possible to limit that evidence, or limit, like, for example, the professional person to certainly they'll consider this, but this is what is, it's tricky as to their testimony. We have to respect the prior jury's verdict. And once, and it certainly as the evidence was presented in this case, we can see the cascading effect of what happened. We get to the state's closing argument, and they're arguing to this jury, she hasn't been getting the treatment she needs for 2 weeks, basically saying, don't waste any more judicial resources, don't make us do this again.
But wouldn't
fail
it be
her again.
respecting the prior jury's decision to have conceded that she suffers from a mental disorder, since they had just a few days before found that she did suffer, and then only confined?
I think they essentially did. I mean, this second trial was really primarily based on her requiring commitment for inability to care for her basic needs.
Right, so the problem is that her condition had changed. After her first release, she has a rough night. She thinks the guy who's taking her in, she thinks he's going to kill her and rape her. She calls 911, runs away. She's gone from 80 pounds to 76 pounds. I mean, things are getting worse. The testimony that I saw from the professional person was she was this bad first time, she's this bad second time, she's gotten worse. So how is that not relevant for the jury to consider when they also heard the first jury didn't commit her? I mean, they weren't deceived as to the first jury verdict, were they?
Well, they were deceived in the respect that they were essentially invited to reconsider that decision and say, you know, this jury let her out on the street. This is why we're in this position, and this is why we have to do it again. I mean, all of that goes directly against the preclusion doctrines and how we respect juries' decisions. And I wouldn't, this isn't just because this is a jury trial, it's more explicit, is that we have a jury trial where the evidence was developed so explicitly. But even in a judge trial, we have an adversarial system is what the legislature gave TW, a third party considering these facts and deciding based on them whether she required commitment. So she could testify.
What you're advocating, I mean, is essentially what the court did in LCB, though.
Yes.
I mean, it specifically excluded any of the evidence prior to the previous determination.
Correct, and that's what we're arguing. If we get past the motion to dismiss, that's what we're arguing. Yes, should have happened in this case.
But I mean, to be fair, and I recognize that this is a balancing act. I mean, that would be, as we noted in LCB, I mean, that would be respecting the previous jury's determination as it pertained to the evidence that was presented to that jury, because a person can continue to decompensate.
True.
And so if that's done, then, I mean, do you take any issue with that?
So I think, you know, in this case, Valancourt, she could testify she'd seen deterioration, but the state's case is not. They do not have an element of proving deterioration. That's not how they charge this case. They're proving that at the later point in time, she is unable to care for her basic needs. Now, if Valancourt has seen this, she can say she's deteriorated, but she really needs to focus this jury on what happened after the verdict to respect.
Because the stuff like the suicidal ideation and the attempted suicides, those were all considered by the previous jury.
Correct.
Right, but all these factors are not just a moment in time. They're predictive. They're really predictive. Are they unable to care for themselves? Have they recently caused injury to themselves or others because of mental illness? Will their condition predictably deteriorate? I mean, that's the problem I have is it's literally framed to look at the history of the person, their prior diagnoses, their prior admissions. I don't understand how you can sever those, even if it's a bench trial. You can't look at the fact that they were committed a year ago. Is that what you're suggesting? It seems to me you're going to cut away so much evidence as to the person's condition now and in the future based on the past.
So, Your Honor, As I disagree with that the statutes are requiring this full length testimony as to their entire mental health, proceeding. If we look at 5321-190, there's actually a statute that says that the fact a person has been subject to mental health treatment is presumptively not admissible in cases. So we're really, what the legislature gave TW was this adversarial process. She can be committed to the state hospital if the state proves that she has a mental disorder and is unable to care for her basic needs. And as I was saying, the mental health professional will know the history and potentially what could happen here, which did not happen here. We again had the second case represented within the first case represented in the second case, but that the professional person could potentially testify to some limited facts for context as to what had happened in the past, but that could potentially need to be subject to a limiting instruction, because as this court's precedent is recognized, that cannot come in as substantive evidence. It can only come in to serve as the basis for her expert opinion. So again, all of these things that did not happen in this case, which really comes back to, the district court categorically ruled claim or issue preclusion was off the table, and then this case got mixed up as it did, leading to the closing arguments that we have, where the jury is basically told, don't fail her again.
Well, it seems that you're asking for a categorical ruling the other way, and I think even your reference to 190 doesn't really support that, because the rest of the provision says, unless it is necessary to determination of the present condition of the respondent, so on and so forth, and the judge determines that the need for the evidence outweighs the prejudicial effect of its admission. So it seems that it really isn't a matter of claim and issue preclusion, but discretionary with the court.
Well, so Your Honor, we're saying that the court shouldn't hold that claim or issue preclusion is categorically off the table, but we do need to apply the doctrine and the elements to the facts of each particular case. This case is quite unique in the fact that we have the state seeking to prove her commitment on the same theory of her inability to care for her basic needs, which is pretty much exactly what happened in LCB, and seeking to do so just by evidence that happened later. When they're getting a second fact determination on that same theory, we have to protect the prior determination. And in this case, we would argue it was appropriate for the court to do so by limiting the evidence primarily and first and foremost to what happened after the first jury's verdict.
So that's the path you would have us navigate going forward, because there are a lot of, it's a civil proceeding, but issue preclusion and res judicata really are not, don't respond to the problem here. So what you're suggesting, I think, is that the judge can allow some of that evidence in, which addresses the concerns that we have about the history of the respondent, but that should not, that there should be a limiting instruction. Is that what is that how you want us to go forward? And that there was not one here. In fact, there was reference to the prior jury's verdict.
Well, there needs to be a limiting instruction, and the state can't put on the same exact witnesses that they just presented to testify to the same substantive evidence of exactly what was happening at the prior time, and really getting the jury to look at this from a 2-week standpoint. The preclusion doctrines, I think, can apply effectively in this scenario, and the court can craft a rule that acknowledges these are quickly changing situations, perhaps if we were in an imminent threat scenario where things change quickly. But what happened here was this jury was tasked with relitigating a prior verdict, and that violates issue preclusion and really the fundamental fairness of the proceeding, and TW's really, essentially the fairness that she was entitled to respect and the stability that she was entitled to rely on for the first jury's verdict.
All right, thank you.
I'll read
Can
it,
you add 3 minutes for her rebuttal? Go ahead.
Thank you.
Mr. Tudor?
May it please the court, my name is Thad Tudor. I'm an Assistant Attorney General with the Department of Justice, and I'm asking this court to affirm the commitment of TW because the district court did not abuse its explicitly given did not abuse its discretion when with respect to ordering the appearance of TW, that the second petition, which was filed after TW called 911, then fled from the police officers, was not barred by res judicata or collateral estoppel, and that any error in this case was harmless. The newly discovered evidence that preceded the second petition included approximately 40 minutes of Deputy Smith's body-worn camera footage. In that 40 minutes, and I'll talk about specifics later on, TW presents as profoundly mentally ill and desperately in need of treatment. And in that respect, this is not a closed case.
So are you conceding then, sir, that maybe the state could have proceeded based just on that video showing what happened after the first trial?
Yes, I think you'd need the testimony of Mavis Valancourt to put some of that into context, but that's all they really needed.
But that's not what they did,
That's
right?
not what they did. And I'll get to that in just a moment. I'd like to start with the statutory scheme because, as counsel thoroughly pointed out, I really dropped the ball in my appellate brief on this issue. And I think the statute to start with here, because the specific rules over the general would be 5321-126.
And can you get closer to the microphone also, or
Sorry,
move
Your
it
Honor.
towards you?
5321-126, under the heading Trial or Hearing on Petition. The respondent must be present. Those are the first 5 words. Unless the respondent's presence has been waived as provided in 5321-119, parens 2. Full stop. There's no discussion of subsection 140, 119.1. If the respondent is going to waive their presence at trial, it has to be done pursuant to 119.2. That sentence does go on to point out that the respondent has a right to counsel throughout the proceedings, but again, no reference to any other mechanism to waive your presence at trial other than under 119.2. So, go to 119.2. The right of the respondent to be physically present may also be waived by the respondent's attorney and the friend of the respondent with the concurrence, and Justice Swanson pointed this out, with the concurrence of the professional person and the district court. Now, one major difference between the first and second trials, in the first trial, the district court concurred, will waive her presence. In the second trial, he did not.
But isn't the right to a jury trial one of the rights that a respondent has? And how does that tie into your opponent's argument that the word also in subsection 1 would clearly allow the waiver? That's one of the rights the respondent has. So why wouldn't it be just an alternative way that a respondent may seek to waive, or may end up having a waiver under 2?
Because the statute directly on point, most directly on point, governing appearance at a trial or hearing on a petition says you can do it in one manner and one manner only, and that's under 119.2.
Okay.
I don't know of another way to interpret that statute.
So 119.1 has no meaning?
No, but
Well, what is the meaning then?
I don't know. I think it's superfluous.
Well,
But in this,
119.1 certainly applies to waiver of rights. I mean, that's what it says.
certainly. And
You can waive you can waive having a friend, you can waive being dressed in your personal clothing, right? Or is that what we're talking about? Are there other rights that can be waived under 119.1?
I think other than your right to representation, and there's one other one that.
Well, actually, it's
Right or-
115, the right in any hearing to be present, to offer evidence and to present witnesses in any proceeding concerning a person, and that's under 115. Now, that's the notice that has to be provided.
Yeah,
But it-
115. I'm
Go ahead,
sorry.
no, go ahead.
115 sets forth a lot of the procedural rights of the respondent. It doesn't indicate or imply there's a right to hide oneself from the finder of fact. That's not implied. In fact, it does specifically provide under parens 6 that they have the right to remain silent. Why would they need that right if they can just hide their entire being from the jury?
Well, because they could want to attend but not testify. I mean, that's, you don't have to, it's not an all or nothing proposition. You either you either show up, or if you show up, you have to testify.
Well, respectfully, Your Honor, I would, it is an all or nothing with respect to concurrence of the professional person in the district court.
No, but you're saying, why would they need the right to not testify if they could just hide? Person could still want to attend their own commitment hearing without testifying.
Yeah, but also it's a civil proceeding. And so without that right to remain silent, the prosecutor could technically call the respondent as a witness. And that probably is what would have happened had those statutory provisions not existed. Now, I stand by what I said in my brief. I don't think subsection 140 applies to this particular situation. I wish it did, because it makes things a lot clearer. Under 140 parens 2, the respondent's presence may, in the discretion of the court, be satisfied either by the respondent's or patient's physical presence, or by two-way electronic audiovisual communication. So there's two ways to satisfy your presence, and two ways only under 140. It's important to note, counsel specifically did not object under 140. And I would suspect there was a reason for that, because had he convinced the district court that 140 was applicable, there was only one option. She can appear by two-way electronic audiovisual communication, or she can be physically present. I think the record here makes it pretty clear that the district court would have said, you know what, you're going to have to be here when the jury listens to this case. One final statutory provision that I'd like to get to is back to subsection 126 under subsection 4, which talks about the professional person may testify to the ultimate issue of fact. But the statute continues, the testimony of the professional person is insufficient unless accompanied by evidence from the professional person or others that the respondent's mental disorder has resulted in the respondent's refusing or being unable to consent to voluntary admission for treatment, and will, if left untreated, result in deterioration of the respondent's mental condition to the point at which the respondent, and the relevant portion says, will be unable to provide for the respondent's own basic needs. The last sentence there is perhaps one of the most relevant to this situation. Predictability may be established by the respondent's relevant medical history.
So what, I lost your, where are you, what section?
It's subsection 4,
Of 126?
small letter D, yeah, of 126.
Okay, go ahead.
Small letter D, and then capital C, and then two
Go ahead.
I's.
Okay.
State would submit that this statutory provision is just a common sense reflection that you can't prove that something has deteriorated without showing how it originally was. The before picture, if you will.
Okay, before you go fully into issue 2, your brief on page 6, you recite the district court's reasoning for why the jury should be able to see the respondent, saying the jury should be able to observe this, it's appropriate. We're asking the jury, by requesting these jury trials, we're asking them to basically observe TW. So going back to opposing counsel's argument that this puts her as Exhibit 1 on display in the courtroom for the jury, and that it potentially violates her right of dignity. What's your response to that?
I believe the exact quote from the district court was, we're asking these people to act as mental health professionals. No psychiatrist with a medical degree is going to opine that somebody needs to be committed without actually seeing that person.
But we're not asking them to act as mental health professionals. That's why we have mental health professionals. We require their testimony.
Well, you're asking them to make a decision regarding whether that person requires commitment and whether they're mentally ill.
But they don't do it as lay people. I mean, they do it as lay people. They make findings of fact. But they're not making a mental health determination. You can't do it without the professional person opining. I mean, they're not experts. And so, I mean, I guess one of the things I have a concern about is when we're talking about an individual's personal dignity, is that it's very clear, I think reading the transcript, it's very clear that that is what was happening here, is TW was being brought into court as an exhibit. And when you have people who are in a fragile mental state or in a compromised state in some fashion, I mean, part of it may be, as she alluded to in this particular case, is they may be aggravated or antagonized, and which may further compromise their mental health by, having somebody testify, whether it's a family member or what have you, and when is there a balancing act? When do they have that right to assert their right to personal dignity, to not be present, particularly when they're being present as an exhibit?
Well, Your Honor, I'm stuck with the arguments and the reasoning of the district court and the elected official in this case. But, of course, you want a jury to make a decision on evidence. The idea that how a jury interprets evidence can't be affected by certain things, how it's presented, who presents it, and even...
So her outbursts are evidence?
No. And Your Honor, what do we actually see on the record with respect to outbursts? I would submit very little. She was apparently crying during voir dire. Counsel brought that to the district court's attention. His response was, this hasn't been a problem. She apparently was talking to somebody, jail staff, I suppose, who was seated with her. The district court explained to the jury that that is what was occurring so they wouldn't think she was talking to herself. She was apparently organizing or inventorying personal effects, don't know what they were, don't know what significance that would have, and she was mobile. She got out of her chair. I think the last thing was at some point she had revealed a tattoo, which hardly makes her an outlier in this day and age. And she did the same thing in the officer's body-worn camera footage on August 27th. She was very proud of her tattoo. She showed it to the officer. So none of that stuff that makes the record, I would submit, would have any effect on the jury's analysis.
But, Mr. Tudor, they did that for a reason. They changed strategy for a reason.
Certainly. They did.
And so now we're supposed to say that strategy of them, the jury observing her, was inconsequential because of what actually unfolded.
Well, the only time anything she did made the record outside of what I just said was she said to her mom, hey, stick around and watch the rest of the trial. So I don't know how you look at anything that happened, regardless of their reasoning for wanting the jury to be able to see her, how any of that was prejudicial or would have affected.
Well, it's probably the biggest difference between trial 1 and trial 2.
No, Your Honor, I respectfully disagree. The biggest difference was that 40-minute surveillance video. You have to watch that. This is not hyperbole. I can't overstate what is seen on that video. There's a very precise reason why that's not being addressed by counsel. Now,
Well, I have a more basic question. Sorry. Did you want to go?
Well, on the issue of this section 53-21-140, where you say there are only two options, that either the respondent needs to be present in the courtroom or appear by two-way video, that subparagraph 2 that you were referencing basically starts with whenever the law requires that a respondent or patient in any of the hearings provided for in subsection 3 be present before the court. What does that mean then? I mean, when does the law require it? Because the presence in the court is something she can waive.
well, I'd again cite section 126, the first 5 words. The respondent must be present. She can waive it, but again, she can waive it pursuant to 119.2. I don't see another statute.
But that just says, but it says when the law requires her to be present. And what does that mean if she has the right to waive her presence?
Well, she has the right to waive her presence pursuant, well, with the concurrence of the district court. She didn't have that in the second trial.
So counsel, and following Justice Bittigary's comment, if you look at 126, and actually the whole scheme and having, and knowing how these types of proceedings unfold, it would be very easy to conduct these proceedings in the absence, and probably preferable to a lot of the parties, including the judge, of the respondent. So in my mind, these statutes are designed to ensure that a trial does not occur in the absence of the respondent. And so when we're talking about 126, the respondent must be present. I mean, we're reinforcing that concept that this is the respondent's trial and that the respondent needs to be there. But they still have the right to waive under 119. I mean, why isn't that a fair reading of this scheme?
Maybe I didn't follow. I think I agreed with everything you just said.
So let me get to my basic question. Let's assume hypothetically it mattered that the jury could see her between trial 1 and trial 2. Why is that an error? I don't understand why that's, number one, does it violate her right of dignity? Number two, why is that an error? That's the fundamental of an American courtroom. The jury gets to see either the defendant or the respondent. We always say they're Exhibit 1. Why does that somehow violate her rights?
I don't believe it does, Your Honor. I'll get to it again when I discuss harmless error, but again, there's a reason the district court has discretion about whether or not he concurs with her waiving her physical presence.
Well, except for the jury is to decide, render its decision based on evidence that is in the record. And we were referring euphemistically to her as an exhibit, and the chief is correct that, we say that when you have a client, that client is Exhibit 1, but I mean, that's a euphemism. I mean, her presence, whatever they are, whatever her conduct was in court, which was clearly the purpose of requiring her presence at this hearing, is not evidence. I mean, it's not evidence presented in the record. It's the jury. So isn't the jury then, by requiring her to be present so that the jury can observe her, but not hear testimony, just observe however she comports herself, aren't we asking the jury to render a decision based on observations that are not part of the trial record?
Not once in this trial did the state ask the jury to rely upon.
No, but that was the reason. I mean, unambiguously, when they required her presence at the second trial, I mean, that was the explicit reason. And the judge said, we're asking the jury to decide they should be able to observe her. But that's not evidence. So what we're effectively saying is we want the jury to be able to decide this case based on the evidence presented from the professional person and also on some stuff that's outside the record, that being how she comports herself during trial, isn't it?
It is.
Okay.
The counter to that is you're asking this lay people to make a decision that has a critical, significant impact on this person. You want to preserve their dignity, and you're going to say, we want you to make that decision, but you don't get to see the person. Don't get to see if they can sit through 2 hours of a court hearing. If there's no further questions, I'd like to move on to res judicata and collateral estoppel.
Well, and this is on that topic, but I guess if you could work it in, I just see a lot in the evidence presented that goes over the top in terms of the reference to the prior jury's actual verdict, and could you address at some point how that doesn't usurp the second jury's responsibility in making a verdict decision?
I would note that trial counsel's specific objection, once the motion to dismiss was denied, his specific objection was to evidence from the prior trial as it pertains to dangerous. He repeats that a couple times on the record before the court makes its ruling. I don't know what from the first trial that would have precluded. Maybe some statements from Mavis Valancourt, but again, he attacked her credibility to the point that door was going to be opened anyways. And I think the reason he worded his objection the way he did is he knew he had every intention of making that first verdict the centerpiece of the defense. And he did. He was the first person to bring it up. He brought it up repeatedly. He cross-examined witnesses who had nothing to do with the first trial about the results of the first trial. See the cross-examination of Megan Morgan, the nurse who didn't even know that TW existed until the weekend after that verdict. He says, well, did you know that a prior jury determined that she didn't require commitment? I think her response was something like, I guess.
So tell me why that should be allowed. I mean, that's not.
I don't think it's relevant, but the minute he does that, the state necessarily has to respond to that. And every time in the record you see the state mentioning something about that trial verdict,
Oh, I see. I'm sorry.
it is in direct response to something the trial attorney did or said. Direct response. Even in the state's closing argument, there was a sentence. We've observed her throughout this trial. Other than that, her behavior in court was not referenced by the state. Was not referenced. Now, with respect to collateral estoppel, res judicata, both doctrines require a final judgment on the merits. It's the last element in res judicata. It's the second element in collateral estoppel. And this court stated in NRA LCB that a commitment hearing is different from most other civil suits. Finding at one time that an individual does not suffer from a serious mental illness is not intended to be a final and irrevocable decision on that individual's mental health. The statute contemplates that the question of whether an individual is seriously mentally ill may be brought at any time as long as the statutory criteria are satisfied. I'm sorry.
You're good.
People are just leaving.
That's not because of you. Don't take that.
Now, NRA LCB is extremely similar to this case in a lot of ways that aren't readily apparent without knowing what went on behind the scenes in this case. But the district court heard the first trial in NRA LCB. He grants a motion to dismiss. We're not entirely sure from the opinion what that motion, why he granted the motion, but it does indicate that the court felt that the testimony concerning appellant's inability to protect his own life or health was simply too speculative. Then, court dismisses the petition. LCB is being discharged from the jail. Flathead County officials discover, oh, wait, we don't have any place for this guy to shelter. He's got no place to sleep. He's too mentally ill to stay at the Community Crisis Response Team safe house, and his own sister is afraid of him. What are we going to do? The different professional person I would submit in this case is a mere coincidence and does not relate to the court's holding in NRA LCB. It's worth noting both professional people in this case, the first one and the second one, diagnosed him identically. They diagnosed LCB with chronic paranoid schizophrenia. Worth noting, before I move on, the symptoms that the respondent had in LCB. He was not eating. He was not oriented to person, place, or time. He was having auditory hallucinations that impaired his ability to process information and respond to even the simplest of tasks. Now, that should sound somewhat familiar, although I would assert that the symptoms of TW were even more severe, and the jury saw these symptoms manifest themselves with their own eyes and ears.
The other thing in LCB, though, too, is that, as this court noted, is the district court expressly prohibited the introduction of evidence relating to the appellant and the time period prior to the first hearing.
And we don't know what that evidence was. In this case,
Well, it was the evidence that was relating to the appellant in the time period prior to the first hearing.
certainly, and it was the same district court that heard the second trial. What happened there is pretty much identical to what happened here. The finder of fact determines that the respondent is probably mentally ill, doesn't require commitment. Subsequent to that determination, all of a sudden the state receives irrefutable, compelling evidence that this individual can't care for themselves. In this case, rather than having people determine that we don't have shelter for you, they actually cut TW loose. She was able to maintain shelter for one day, one night, prior to calling police and then running and fleeing from them. She was not oriented to person, place, or time. She was not eating. And again, with the symptoms of eating and sleeping, I think one of you hit on this with your questioning, those symptoms aren't like a headache or a muscle strain. They're not going to become less serious with time. If an 80-pound adult isn't eating at one point, jury might say, no big deal. If that same adult is seen a week later and still not eating, that's a whole different symptom. I would argue it shows deterioration, and it's something that needs to be addressed. Same with sleeping. Valancourt testified a few times that her lack of sleep was exacerbating the auditory delusions and hallucinations. And again, you can see that on the 40 minutes of Deputy Smith's body-worn camera.
Mr. Tudor, can I go back to my, I don't have a problem with the second petition being brought. I think the evidence clearly shows that there was decompensation. You're more familiar with the record than me. The reference to the prior jury verdict specifically, that the jury 2 weeks ago found this, and saying that to the second jury, who made those references? I thought it was by the state?
Each and every time, including the first time it came up, it was the TW's trial attorney. Every time. I believe when it came to Valancourt, who was the state's last witness, at that point, after the jury had heard all this evidence that was it was introduced to the trial by the defense attorney, at that point, the state might have introduced the actual verdict form through Valancourt, and that might have been trying to anticipate what he was going to do on cross-examination. But
Did that follow the judge's determination that that evidence would be admissible pre-trial?
yes, that
Okay.
before trial, the judge says it's
Right.
all coming in.
And during that pretrial discussion, was there any parsing out or it didn't seem like anybody talked about whether to preclude the jury's verdict? I mean, that was confusing to me, that it was all about the evidence of her mental state and dangerousness that was at issue. But there doesn't seem to be any discussion about the trial itself being off limits.
No, and in fact, when TW's trial attorney clarified, I'm objecting to evidence from the prior trial in terms of dangerousness. There's no further clarification of what that meant, because the district court said, no, that's relevant medical history and it's all coming in.
The judge was not asked to rule in limine that the jury's verdict could not be presented.
He was not.
Okay.
Now, the state submits the reasons for not modifying or overruling LCB are self-evident from the opinion. What was the district court supposed to do in that case upon learning that this, in the opinion's words, this very troubled young man had no place to sleep, no shelter? Sorry, I already made that determination that he didn't require commitment. We've got to put this off. Now, if that sounds sarcastic, it's not. That is literally what counsel is arguing by suggesting that we get rid of or modify LCB. Now, I haven't heard a specific suggested modification as to, or clarification that counsel would like in terms of LCB. The only one I recall was from the appellant's first brief, where she says, you've got to allow for that second petition has to be sometime later down the road. And I would argue that this case, the facts of this case, and LCB shows that later down the road is too late. If the state or a district court if the state is not allowed to file a subsequent petition upon obtaining irrefutable evidence that this person is not going to be able to care for themselves and they're going to harm themselves or others, counsel talks about dignity. What kind of dignity would that have been for the state in this case to say, well, yeah, she looks mentally ill, but the jury already said she doesn't require commitment. Let her go. Let her wander around Libby.
Well, in the absence of, and I take your point. I mean, what we have here is another triggering event. I mean, in the absence of some other event, which we did have here, I mean, wouldn't you agree? I mean, you can't just retry them because you didn't like the first verdict.
Yes, I would agree with that. I could take my analogy back a step, and again, see this on the body-worn camera of these officers. These officers are called, they get a 911 call. TW is concerned that her adoptive father is going to harm her. He has a gun under his bed. She flees from the police. The officers are eventually able to cajole her into voluntarily going to the hospital, to the emergency room. She gets there, and as she's prone to do, as the record shows, she changes her mind. She doesn't want to go into the ER, and you can actually see the nurse say, well, nothing we can do. What would you have the police officers do at that point? If they're barred from trying to seek any kind of commitment, they have to, pursuant to her request, let her go down to the river and pray. And if you watch that video, you'll see that was just not an option for two responsible police officers.
So let me just, I know we're out of time here, but I want to just briefly, give me your 1 minute harmless error closing, because I'm not sure that I've heard that really from you.
Well, on this videotape, the jury saw TW not have any grasp of reality. I'm not sure she knew who she was at certain times. She talks about Elon Musk, Ariana Grande, and Donald Trump, repeatedly talks about them hacking into her brain. She is obsessed and even preoccupied with rape. Detective Holzer testifies that on August 29th, he's taken her to the state hospital, and she tells him, hey, I'd like to put on some makeup so I look good for when you guys rape me. This videotape was created, couldn't have existed after the first verdict. And with that videotape and with the testimony of Mavis Valancourt, I don't know that any of that evidence from the prior trial would have much of an effect on the jury's verdict at all.
Any further questions from anyone? All right, thank you.
Thank you.
So on the compelled appearance, the state apparently now seems to be making an argument under 126.1. If this court is inclined to rely on that provision, since it wasn't brought up in the briefs, we would request the court consider order supplemental briefing to really provide my client with her due process rights. If the court wants to follow 126.1, it will have to overrule several, like 2 decades of precedent in Real K, the 2009 case, in Re PAC 2013 case, in Re SD 2018 case, and in Re JDL 2023 case, where the court has always provided that the presence waiver can be done in 3 manners. Importantly, that's also not the section that the district court thought it needed to proceed under in the first trial in this case either. I would like to correct the record. Counsel stated that the state didn't refer to the jury's, to her being in court in the closing argument. The state did in fact resort to, you can see your observations of her in the closing argument, which was a reference to her appearance in court. As I hear the state's argument, I haven't yet heard them argue that, they don't appear to argue that address this court's precedent that as to the reversible nature of this error, that this court's precedent has consistently held that this is reversible error where a district court violates the waiver statute. The state hasn't addressed that. That is about giving strict compliance to the waiver precedent, the important rights at stake. And here I would submit this is a particularly egregious error where she was forced to let herself be inspected for the purposes of the state's case. And as far as the body camera video, that is a different character of her presentation than what we would submit what was in court. In court, she was watched by the jury over 2 days from this separate room. This was a week and a half down the road. Again, we don't have an expert who's really telling the jury. I mean, the jury's just serving as its own prejudicial fact finder as to whatever she's doing is probative of her mental state and her need for commitment, which the state clearly believed it was.
Counsel, just picking up on Mr. Tudor's where he kind of left off, we do have another incident. So, I mean, I take your point, and in LCB we talked about segregating the evidence from the first trial and the second trial. But, I mean, the point is well taken. There was something that occurred. She calls 911. She has this interaction with the police. I mean, they can't be expected to just ignore it. I mean, the petition, and I think it's a separate issue as to what that opened the door to in terms of from an evidentiary standpoint, but this wasn't just a second bite at the apple because they didn't like the first verdict. I mean, there was a precipitating event.
And we've agreed under LCB, the state can file a new petition. We're not saying the state can't file a new petition. We're just saying that petition should be subject to claim or issue preclusion. And that is what protects from what we all think shouldn't happen, where the state just turns around and refiles the petition because they don't like a jury's verdict. Preclusion is what keeps that from happening. The state cites 126.4, the deterioration prong of a person requiring commitment. That is completely inapplicable in this case. The state did not put that did not put that in the special verdict form for asked the jury to decide that she required commitment on that basis. And the reason that they didn't do that is because deterioration under 5321-127-7 is not a basis does not authorize the court to order a person to be committed to the state hospital.
Right, didn't the jury decide under A, B, and C, substantially unable to provide for their own basic needs, recently because of a mental disorder or act or omission caused injury to self or others, or imminent threat of injury to herself or others? Were those the three? I know A and B were, I believe. I'm not sure about C.
A and B were what the jury found in the second trial.
Okay.
And A, B, and C were presented to both juries, and the second jury did also not find under subsection C.
Okay, so back to those A and B, don't those allow the evidence of decompensation from the prior week or the prior 2 weeks and looking at recent acts and omissions? I mean, how do we exclude that evidence, which seems very relevant, from the week or two prior?
As we've discussed, the professional person is going to be aware of everything that's happened, and it could be possible for them to stay in a limited fashion what they have seen in their opinion and what they're basing their opinion on. But I mean, as Justice Shea pointed out, this is a new case. These are new facts. The case should depend primarily on those new facts. And so that's why we can't have really substantive evidence that we already presented that the state lost on. And I would submit that it would be appropriate in that instance for the rules of evidence to really come in working with the preclusion doctrines to make sure that that gets to the jury in an appropriate way.
Counsel, I want you to be able to address Mr. Tudor's response to, I think, Justice Baker and my question about whether was the record preserved as to reference to the judgment, the specific finding of the prior jury and in the second jury trial.
Yes, it was. The district court's pretrial ruling was based on the state's representations of LCB, where the state said that LCB says claim, and they represented it as saying both claim and issue preclusion.
But I see a distinction between evidence of mental health problems, disorder, and evidence of a prior jury's determination. I think there's a big difference, and I want to know whether the record flushes out that difference was observed by counsel and adequately objected to, or should we exercise plain error review?
It was adequately objected to because the district court's ruling was categorically claim or issue preclusion are off the table, and I'm not going to limit any of the evidence of what happened in the second case. I think that is implicitly encompassing in that the jury's verdict, and why the state didn't object when the defense counsel started using what the ruling allowed him to do, was trying to use that jury verdict as a favorable fact. I mean, if we're just letting it all in, then he should be able to say, well, a prior jury, decided that she did not require commitment on this evidence, which really opens, to what happened. So it was really a fundamental incorrect ruling at the pretrial stage that set the stage for this, and was adequately preserved the issue. And at the state, importantly, we would submit that the state miscited LCB to the district court on the limitation of the evidence issue. The state actually told the district court that LCB had said relevant evidence can come in on a preclusion basis, but LCB had exactly held the opposite, and that's what we've been talking about. On the preclusion issue itself, they had determined the issues were not the same because the district court had limited the evidence to what happened subsequent to the first case. So that's kind of why the district court didn't think it was an issue to let it all in.
So if we were to find that the second petition was valid in theory because there was new evidence of inability to take care of basic needs, or the A, B, and C that the state alleged, and we agree, let's say, that it was wrong to admit freely all of the information from the previous trial, what are you arguing is the proper remedy? Are you arguing for outright dismissal of the petition, or some kind of a new trial which I know it's impossible in this case because we're so far down the road after this all happened, but what remedy are you asking?
I got it. Thank you.
We were going to set you up and ask you this great question and then not let you answer it. No, go ahead, answer it.
Thank you, Your Honor. We're asking for a reversal of the commitment. That's the way the court can provide justice in this matter. We can't retry DW. She's served her time at the state hospital. And unfortunately, I haven't had time today to address the state's, the harmless error argument, but I dispute that she was profoundly sick. If that was really relevant to her mental disorder and not relevant, as the state characterizes it, as to her ability to care for her basic needs, and which was the finding in this case.
Okay. Yeah, I guess I would just say this. Here's what we're stuck with. Future difficult questions where in this case, if we make the right, provide the right remedy, doing what you want, we don't want to do it in such a broad net that it misstates these statutes or creates a future situation where it basically prevents someone from really getting the help they need. That's a fine line in this case. That's why we argued it, because it's unique. I don't know, last words on that?
Your Honor, I would submit this is a unique case in how the state presented it to the first jury, how the state presented it to the second jury, that we have the same theory, that we have really the same essential facts, statements about her. She's making the same statements that she's fearing the hospital is harvesting her organs, that they're trying to hack into her brain, but she's also pleasant, cooperative, at times seeks mental health treatment. So, I mean, that's why this was a close case and why the state worked as it is to try to get in that prior evidence.
Okay. Thank you.
Thank you, Your Honor.
Thank you, counsel. The case is submitted.